Good morning, everyone, and thank you for attending today in person and for those online as well for our April Aitken Partners Breakfast Seminar Student Migration and Sponsorship topic. Today we'll be dividing key updates and practical insights on migration law. For those of you who do not know me, my name is Bao Ngo, and I am a principal lawyer at Aitken Partners, and as of recent, the new head of department for the migration team. So today's session gives focus on unpacking the key developments in Australian migration landscape, particularly across skilled migration and employer sponsorship. And with the number of regulatory changes taking effect this financial year, it's an important time to step through what's changing, what it means in practice, and where we're seeing the biggest impacts for businesses and individuals. We'll cover the current visa pathways available, look at the occupations in demand, and talk through what sponsorship really involves from a compliance and risk perspective. The aim today is to give you a clear, practical insights that you can take away. Whether you're advising clients, managing workforce needs, or navigating the system as yourself. Throughout the session, if you've got any questions, depending on time, feel free to raise your hand and we can answer the questions, but alternatively, having to answer questions at the end of the session as well. And now for our panelists, let me introduce you firstly to Andy Allen, a senior migration consultant at Aitken Partners. Andy is a highly experienced registered migration agent with well over 16 years experience across 4 areas of Australian migration law. Andy combines deep technical knowledge with a practical understanding of the migration journey, particularly for those who have studied in Australia. With a strong background in international education and extensive experience advising both individuals and businesses, Andy is known for delivering strategic, solution-focused guidance across visa pathways, employer sponsorship, and complex matters, including visa refusals and visa cancellations. We also have with us today the Lauraine Nguyen, who is a senior associate at Aitken Partners with a strong and diverse practice in migration law, advising individuals, families, and businesses across a broad range of visa and citizenship matters. Her experience spans straightforward applications through to complex cases involving visa cancellations, unlawful status, and met review proceedings before the ART and the federal court. She also works closely with lawyers on sponsorship and workforce migration strategies. Lauraine is known for her empathetic and solution-focused approach and combines technical expertise with cultural understanding to guide her clients through Australia's migration system with clarity and confidence. Please join me in giving a warm welcome to our panelists. So let's start off with some questions that I have for Andy. Andy, what are the most significant migration law changes coming into effect in financial year?
Probably the fact that the narrative at the moment, as everybody is aware of, is not particularly pro-migration. And therefore, I think the government, through the Department of Immigration, is looking at a way to recalibrate the migration system with a view in the key buzzwords to make it more value-driven rather than volume-driven. And so when I arrived in the country from England 26 years ago, it was a much easier pathway to come and to attain permanent residency. Now it's become much more difficult, much more challenging, and it's almost as though Australia doesn't really need to advertise any more than need to attract migrants. And therefore, totally right about it. Let me just give you some figures about, in fact, let me not give you typical figures. But if I was to ask here in the room, how many visa applications do you think are being lodged every month? I've asked this question over the last few weeks. Perhaps people would come up with a figure somewhere between 20,000 and 50,000, which is a lot of visa applications. except it's a long way off because it's closer to 500,000 visa applications every 28 days. So if 6 million people a year are lodging an application to try to come into the country one way or the other, then from the government's point of view, they do need to think about how is it possible to absorb this demand, and rather how to, if you like, pick and choose. And so that's why migration law has become so complex, because the regulations themselves have been written over a previous regulation to try to improve, to strategize over another regulation, and so on and so forth. And it just becomes very, very, it can appear to the outside to become very confusing. So I suppose what we're trying to do, and what I try to do every day when I speak to employers, when I speak to individuals, is to try to simplify without taking it down to too lower a common denominator. And I think what's happened with migration is that skilled migration has become much more valued than perhaps it was 20 years ago. And the employer-sponsored visa, I believe, is probably the most effective way to counter the noise that's coming from various individuals at the moment in society. Because if the noise says there are too many people and there are too many people who are from wrong places and thought spaces, then the best way I've found to counter that is really to talk about the economy and employment outcomes. And so what we're finding is that the need to basically push that argument and to defend the role of migration through the need to deal with the skill shortages that exist at the moment in Australia. So in terms of specific migration law changes on July the 1st, that's quite difficult to, apart from the fact that if you sponsor an employer, you would need to pay them closer to 80,000 rather than 76,000. It's really part of a general reset that's taking place in really the last 2 years, and will probably carry on to the next few years as well.
And you touch on the experience regarding these pathways in the most recent years, and you talk about a term that the government's using, which is recalibrate things. With that in mind, what do you think that means for businesses in practice?
Well, I think when speaking to businesses, I find that the most important thing to sort of deal with is that they're looking for stability. Now, post-COVID, we saw a lot of people they came back into the workforce and then they want to move on. And I think speaking to people in HR departments, one of the most frustrating things that they came across was this real challenge to maintain their skilled workforce. And so here's a great argument and reason for using an employer-sponsored visa, which enables the employer to keep the employee with them working in the role for a period of up to 4 years. And that in itself provides, some kind of, it's a huge, because suddenly the 482 visa becomes a huge strategic asset.
Thank you, Andy. I'm going to move now to Lauraine. Lauraine, what are the key compliance requirements that our employers, clients need to be aware of?
So we're compliant with sponsoring business has always remained the same. It just pretty much just to ensure your sponsored worker work in the nominated occupation. Now that might sound easy, but for example, if ABF, which is Australia Border Force, that does all the monitoring and the auditing for sponsoring business, come down and do a site visit check and then go and look at the sponsoring worker what their tasks and duties are, and they're on paper a marketing specialist. However, they could see that they're on the floor doing sales assistant jobs, then that will definitely flag a major issue with the department and will trigger a full audit. So the first and foremost is always to ensure that the sponsoring worker works in the nominated occupation. Any changes on that, get advice before, because there are several consequences of changing someone's position, salary, not so much, but position and their tasks and duties mainly. The next one, I think Andy touched on, is about salary. So with the 1st of July comes a new salary. So salary is always an important one. Ensure you are paying the workers the proper salary that you put down in the application. Make sure super's paid. A lot of time is made to get to pay the super. Keep records with the new ATO single payroll touch that now is in place. There is data sharing between the ATO and the Department of Home Affairs. So the department can also just check in to see if what the business is telling the department in terms of are they paying someone compared to what's been reported to the ATO. If it's different, that would then trigger an audit as well. And I think the last one is what we call a 28-day notification, which a lot of sponsoring business forget that just because an employee's visa has been granted, it kind of ends there. No, it does not. So being a sponsored business, you have obligations. So there are certain events that trigger your obligation to notify the department. And that can be anything from, let's say, obviously a change in tasks and duties, a business restructure. So if the business has gone through a restructure, there's a new entity coming, new directors, that actually all has to be reported to the department. Nothing really happens after, but it needs to be reported, because then if the department decides to do an audit and finds out these events has been triggered and you haven't then notified within that 28 days, then that constitutes a breach there. So you also need to know exactly what events trigger the 28-day notification as well.
You touch on these obligations, and so then the next part is what are the consequences to getting it wrong?
So I don't know if most people know, but there's an actual public register of sponsoring business that has been in trouble. So if you go on the Department of Home Aware website and you search up business that have been sanctioned, it actually lists all the companies out. So you can have a little search up there and check out all the companies. You can actually see what consequences for actions the department has taken. So sponsorship cancellation and a sanction. So sponsorship cancellation, it pretty much means they no longer sponsor a worker right then and there. Sanction is they cannot sponsor any overseas worker for a certain amount of period. So for example, about 5 years, usually I think average be about 5 years. It doesn't always lead to that. That's for like major breaches. Sometimes you'll most likely get a non-compliance order from the department, and then after that you then try to rectify it, and then you inform immigration on what you have done to rectify, and then it's up to immigration. They can then just give you a warning or undertaking that you will not breach again, or they can move on to the sanction, the cancellation. The most strictest consequence is actually infringement notices. So the department has rights to actually give out infringement notices and civil penalties, and that can, I think, be up to about, I think it was $80,000 per breach, which can be quite a lot for say, a small business as well. Yeah.
And then how do businesses stay on top of their ongoing sort of compliance and sponsorship obligations?
Yeah, so I always suggest our businesses to do like every 3-4 months, maybe do an internal audit or checking of the records of all the employees they know that are on a current visa. So just go through their records, just do a Vivo. So what we call a Vivo check is that you can check someone's status to ensure that they still have full work rights. Talk to HR just to make sure that their pay slips, all their salary records are up to date. Maybe put in calendars. Let's say someone's visa expiring 90 days before their visa is expiring. So then that 90 days gives you enough time to seek advice and action.
Thank you, Lauraine. And you briefly touched on one potential skilled visa pathway, but What are the key skilled visa options about currently available and how have they changed?
That's a great question. And when I came over, it was about independent skilled migration. So that was dealing with what was your history, what is your skill set that you had previously in your country, how good is your English, how many years of work experience, and it was based on a points-based approach. So everybody became very obsessed with collecting points. First of all, ensuring that their occupation was on the specific list that it needed to be on, which itself was a juggling act. But a lot of people would walk in over the years and talk about their points. Now, I think that's kind of talked about in relation to the Skilled Independent 189 visa and the state-sponsored 190 visa, either Victoria, New South Wales, wherever in the country. So everything was about points. But I think they've realized finally that the point system does not really tune in with the needs of industry. And so the way that this point system was designed was actually designed towards people coming into the country as international students. And so I remember going overseas and speaking to people who'd been working for 15 years in their trade. And I said, you won't be able to compete with other people on the basis of getting the most points to secure an invitation to be invited unless you come over to study and get 5 points for studying for 2 years. Unless you go and study in a regional area in one of the universities or schools in a region area and get another 5 points. And if you want to go and take a translation exam to get another 5 points, you can only take that exam inside Australia. And so the whole thing, this review that's taken place since 2023, I think it's kind of quite rightly identified finally that there's a lot missing from simply bringing people in on the basis of their history. And I think the great thing about the 482 employer-sponsored apparatus is that it's talking about the present and the future in relation to what a migrant can give to an employer and to the economy. And I think that's what's changed.
So would you say then that the base pathway that you think will be most practical for employees versus individual applicants will be down the 482 pathway?
Yes. I think the 482 is going to be the argument against the noise about too many migrants, because when I stand on the sideline at the soccer match with other parents watching my son play, and they ask me what I do for a living, and the conversation regularly gets around to this idea of migration, the greatest argument against the noise is the fact that the migrants on a 482 are of a hungrier disposition than perhaps local workers, and that the skills shortage is not being met unless the migrants come in and take up the 482 visa. And as I say, the need to for businesses to reduce turnover, avoiding this repeated recruitment cycle is the only way really, or is the best way to really satisfy all aspects of the argument.
So you touched on some common misconceptions about skilled migration. I personally had some early in the years before practicing migration law that it probably would have been easy to accumulate all these points, right? But, we joke about it in our office. If I was to do it now, I probably would not be getting enough points. And potentially that's because of my age. I know age is one system. But what are the other common misconceptions to employees or employees may have and the analyzer that you want to share?
Misconceptions. That it's easier. I think there's a feeling that this is easy, and it's extraordinarily complex. So there is a list of occupations which you must fit, unless you're earning and being sponsored by the employer for somewhere around about $142,000 per annum, you would need to fit the requirements of a particular list. It's called the Consolidated Skilled Occupation List. Now, they've tried to make it a bit easier by putting together, and this is where I could really happily lose you, not me being happy and you wouldn't be that. There used to be a medium to long-term skilled list. That was those skills that were definitely needed long-term. And then there was a short-term list, and it was a mess. It became a mess because visa pathways differed. One could move towards permanent residency, one couldn't. So you had a situation where chef was on the medium to long-term list and cook was on the short-term list. A cook couldn't get a pathway to permanent residency, but a chef could. So you can guess what happened. Every cook was a cancer or pretended to be a chef, or it was, it was written in such a way that they were considered to be a chef. So it was a mess. Then they've brought this now into this consolidated skilled occupation list of 456 occupations. Now that's a lot of occupations, isn't it? Except then when you find out the number of professional occupations is estimated at somewhere between 456, 20 to 25,000. Professional occupations can be defined, apparently. So it's a tiny number, isn't it? 456 is very, very specific in terms of the needs of the economy and so on and so forth. And of course, what are those needs and how rapidly they change? People would tell you 5 years ago that if you're a systems analyst, if you're an ICT systems analyst, this is the way to go. And of course now there are more of those occupations being laid off in the last 6 months than actually being employed and being given the chance to be sponsored. But I think the main ones that really where people would be looking at getting a positive outcome would be in the areas of health, of allied health, of care, the care services, of construction and certain trades, but not others. It's very complex. And education. If I was to say to people who walked in to see me, I have the utmost respect with these two boys of mine who are just about to go into high school, the utmost respect to teaching. But if you were to say to somebody that the chances of getting permanent residency really rest on study to become a secondary school teacher, 90% of people would walk away from it. But the ones who take it up succeed. Very interesting. This study to outcome scenario is one way.
And I think luck also plays a part of this out.
I'm curious, what informs that list? And I'm sure that there are groups in Australia that have substantial influence and persuasion over government, which might not necessarily be merit-based, but influence. But how does the government, through this pick within their knowledge, how does that list evolve and adjust? And is it meritorious?
That's a great question. They would handball the responsibility to jobs and skills Australia. And they themselves, and I was at a meeting in November where they spoke about how they come to how they come to actually sort of creating this list. And there's so many factors. Let's take the occupation of restaurant manager. That is still in demand. That is still very much in need. Hospitality is a huge part of the economy. But one of the reasons why they decided to remove it from the list so they couldn't be sponsored was because of the volume of rorty that was taking place. So I can walk you down the road, Alistair, and point out 2 or 3 people who are working as baristas or waiters or waitresses in cafes, and they have visas as restaurant managers. And so this is really one of the, it's a huge challenge for immigration and people in this space as to, an employer wants to keep somebody They want to, every employer wants to retain their high performers. And if that means they're not working in a specific occupation, then the idea is that they might use that beautiful old thing that my father used to put in the back of his shoes to make sure that his foot got into his shoe that didn't quite fit. The shoehorning method of basically trying to organize an outcome. So I think working in the skill migration space from their point of view, the decision makers, is so challenging to make and to try, and it comes back to compliance. How do you check that someone is working as a restaurant manager when they may be doing another particular role? And so for it to be removed from the list was really, not spite's the wrong word, but just a way of sort of sending a warning to the hospitality industry. Don't rot the system. The cooks, the chefs thing was an indication of that. But of course, the biggest barrier for the hospitality industry is when the minimum salary goes up from 76,150 on July the 1st to 79,499, $80,000 to work in an industry which is really feeling the pressures, of wages.
And Lauraine, now to you. So with all these discussions that's been happening, what practical steps should businesses take now to prepare for these changes and in the future as well?
Well, as we touched on, obviously the salary is the biggest one coming up 1st of July. So that will affect any nomination, any applications made on 1st of July or after. So if you have any clients or business that are thinking of sponsoring anyone or have any current employees that the business may be willing to sponsor, I think now, because you're earning about plate, now is the best time to go and just have a look through and talk to HR maybe to get the process started or seek advice, because you need at least 4 weeks for most situations before we can actually submit a nomination application for certain requirements to be completed, at least 4 weeks. So we are about start of May, and so we are cutting it quite close to 1st of July. So I think right now is the best time to go and do that. Secondly, it's coming up to end of financial year, as I mentioned before. Maybe start doing some of the auditing, the checking records now for this financial year before the new tax returns are submitted, or you start preparation for those. Because we do ask for business financials, and the department does look through it in terms of, is the business making enough profit to actually sponsor working employees? Just because you make a certain amount of revenue doesn't mean you actually have enough net profit or there be to pay your employees, especially with the salary increase, right? Because as Andy said, with hospitality, like the restaurants where there's only a one-off, or the small local restaurants may not actually be making enough to sponsor someone who's on 80,000, which is quite a lot for gross chefs. So yeah, maybe right now is the best time to go just have a look through. If there's any employees that you may want to sponsor, go talk to one of us about it. So seek any advice, anyone's visas are expiring, because I think financial year is also a time that a lot of people's visa might be expiring. There's also a certain time of the year where a cohort of visas will expire at the same time for certain individuals. So check through an employee's visa, see if they're expiring. Yeah, and if there is, and you still want to keep them on to continue working, go see the advice for.
So the other thing about the list is that that's actually only a small part of it. And what is opening up if I was to do a little bit of crystal ball gaze, I think that immigration aid, employer sponsorship is going to be increasingly dominated by something known as a labour agreement. And that's where the occupation that an employer wants to sponsor someone to keep them and to retain their high performer, and to develop the business. And it's not covered in that, limited 456 consolidated list of skilled occupations, would be for the company to appeal to the department to say, we have special requirements, special needs, a special skills shortage, and a special economic outlook, which argues that we can then employ particular individuals. Now, there are certain industries that are covered by labour agreements, and the most obvious one probably is the meat industry, where the government decided that, again, as a result of in reaction to the previous sort of rorting and non-compliance that was taking place, then they pulled together boners and slaughterers and slicers and put them into one occupation, called it a skilled meat worker. And so each abattoir could then go and apply to obtain that labour agreement so that they could then sponsor people on a 4-year visa to keep them working in those occupations. But more specifically, a company can go along, and this is increasingly part of our work, is that a company can go along and say, well, the occupation that we need is not on the list, or it's been taken off the list. For example, operators, were line managers, and I was just thinking specifically of beef cattle manager in agriculture, which has been removed from the list. And so the companies are then going to immigration directly to say, we would like a labour agreement because we've got beef cattle managers here. We need forklift drivers as well, which is not on the list. And we'd like those to be catered for our specific individual needs. And so it's a bit of a, forgive me, and I apologise, it's a bit of a wooden approach to say it needs to be on the list. Because I think as employer sponsorship, as the 482 visa narrative really takes hegemony in the migration space, then I think you're going to see an opening up of labour agreements as a way to retain a best skilled labor.
And, we've given some practical insights for like businesses and employers, but like for these applicants themselves, do we want to share sort of key factors that they need to consider when choosing visa pathways? Yeah, you're right.
I think first and foremost is age. It is one of the biggest factors. So most visas in general in Australia, especially for permanent residency, there is cut off at 45 years old. So if you know someone nearing that age, around the 40, might be best time to go and seek advice now.
Unless you get a labour agreement.
Which has concessions.
And there's the beauty of these labour agreements, is that there are specific needs for people.
Yeah, that's fine. Yeah, so as I said, go seek advice, because then we can advise on if there are sort of other pathway which concession on age, like the labour agreement. Second is English. I think that we touched on a bit before. We do find a lot of people struggle with English. So it's always best to improve your English. There are similar labour agreements that concessions on English or something like that as well. So if you know, or anyone who's going to struggle on obtaining a certain level of English for a test, seek advice as well as soon as possible on that as well. So can advise on certain pathways in the future.
I think that's right. English is the main thing, and it's very difficult to say how do migrants get selected to apply for permanent residency for the 189 and the 190, and there's really no, there's no list to say this is more important than the other. But if there were certain things that you could pull out, one is to get the top level of English, and that we're finding that people aren't being invited unless they've got what they refer to as superior English. And secondly, people are being invited for these 189, 190 PR visas on the basis that they have a partner who is also skilled. So it's almost, from immigration's point of view, two for the price of one.
And I think from my observations as well, with respect to the skilled migration visa where this employer sponsorship does involve, there's a thing that a lot of clients are aware of it, and I'm sure I want people I seek advice on the inside on, and that's the concept of something called genuine need. I think a lot of our clients, when we tell them that there is this criteria, they get very shocked by it, and the requirements for us working with accountants to kind of assist them with something called genuine needs submission. So let's just, both you would like to touch on that concept as well?
Labour market testing. This has a fascinating history across migration. I mean, I've been involved for 17 years, but I've watched it for 10 years previously to that, and it's been an on-off requirement. And presently it's on. And it's a very important part of really proving to that noise out there to say that if labour market testing didn't exist, that there would be this accusation that people are bringing people in and they're getting jobs ahead of Australians. And so in the political argument, it's a very, very important, it's a very important factor. The reality of it is that most businesses are extraordinarily frustrated that they don't need to test the market because they've already done that on the basis that the person that they're hoping to sponsor has already been working with them on a temporary visa beforehand for a period of 1, 2, 3 or more years. And and a lot of employers find it a bit insulting, frankly, that they have to go through that. And so what's been a political requirement really for about the last 10 or 11 years is now shaping up from being a frustrating, very frustrating part of the process, is actually being very much part of the important message, which says that people are given the opportunity to apply for these jobs. And in many cases, hundreds of people will respond to an advertisement. And the employer then has to just think about how they're going to shape the person, that they've got skills of that person to make sure that they can justify taking on this particular person.
What about you, Raif? Could you just share?
No, I agree. So I think most of our work is done at the labour marketing stage as well. So working with HR of a business, once they advertise and then we ask for recruitment or the resumes and we go through it, we work the HR. You actually do have to provide a report of why certain people, why you couldn't find anyone else on that list but the person you want to sponsor. So that is actually one of the most complex part of our work. I would have to say it's the recruitment summary that we then, the businesses through, then we review before it's submitted to the department. I do say genuine position is the majority of the reason why applications are refused by the department. And there are some businesses will be like, oh no, but there is a real genuine need because the person's been working before us. But from the immigration's point of view, let's say it's a small restaurant where there's the departments, in what the department understands of a chef, let's say, is that one restaurant already has one head chef and then one sous chef, right? So if it's a very small restaurant and you're going to then be like, I want to sponsor a second sous chef, you then have to actually justify that as well. Why second sous chef is needed, where your business operation is quite small. So that's also another thing that's very complex for us as well. We ask for all the business operations, all the work, all the organization chart as well, because then we have to show the department that why there is a certain need for this position. If there's already someone working very similar position in it already, for larger business organization, it might be easier, but for the smaller ones, some of it can be quite hard.
Does everyone a salary?
Yeah.
Because I think everybody says, well, I can afford to pay $76,150. But if that's not the market salary rate, then the nomination and the visa will get refused.
And it's both ways. So a chef getting paid $80,000, which is a lot. I think on my chefs around 60 to 70,000 max. Maybe fine dining is about 80 to 90. So unless your business is a fine dining, it's actually quite hard to justify why you're paying a chef at 80,000. Vice versa, yes, even though the minimum salary to be sponsors is moving up to close to 80,000. Let's say your engineer, the average salary engineer is 100, 110. When a business comes back to us and they're like, but we can't afford to sponsor someone at 110, then that may then bring up an issue of them can you actually afford them at the market salary rate, and then you need to justify why you are paying them lower than the current market salary rate as well. Yeah.
I find that it also helps to work. So we work with accountants. I think accountants who have been an accountant but so business for like decades, generational accountants are quite helpful as well, because they provide us with report and assist with our submissions with respect to talking about this genuinely. And if a business is really not doing well, say it's certain quarter, they can actually assist with preparing projections, which is really, really useful. And those are things that like we as lawyers cannot comment on or advice on them in accounts, because that's just that prepare those projections, which I think can be very persuasive in assessing that sort of genuinely. I tip you out a question there. So
Yeah, Andy, we talked about right at the beginning about values-based versus wanting-based. Now, there's the talk in the political sphere about all these things anyway. I have a two-part question. What is about the values? How do you assess those values? Because how do you assess those values? Because anyone coming to any organization and say, oh, I align to your values, therefore I would like to work for Advent or something. I'm just giving an example. That's one thing. The other one is, we talked about the labor market. Now, people are moving towards the robotics and AIs and all that. Now, given those is having a rapid momentum, where does it all lie up for people like restaurant managers or even chefs sometimes, cooks or somewhere, because they are using robotics to do all that. So in 10 years' time, would you really need such skills, if I can put it?
Yeah. And that's the question, isn't it? Which jobs are going to be around in 5 years' time? Which ones are going to be needed in terms of, jobs with creativity, with human creativity? Teaching's an interesting one, isn't it? Because supplying information to students is one thing. But teaching is something completely different as a skill. The creativity, the nuance, and so on and so forth. So I think value driven. I mean, these are expressions that are not mine. They're just used, aren't they, by the department as a way of really saying, I suppose, to stop this idea of saying that we're just taking everybody and anybody. And that's why I think that I think that if you were to rewrite immigration, I think you'd do away with the 189 and the 190 visas. Because, as I say, they are a reflection, an invitation to apply for permanent residency is actually a reflection of someone's past, not the present. And the point is that people could get their permanent residence on the basis of having had that experience, had those qualifications, got good English. But you see, immigration has failed to say that the person needs to carry on working in that profession for which they got invited for permanent residency. And I think the thing that took place in the last 15 years, 20 years around accountants, where students would come in and study an accounting degree and call themselves an accountant, whereas 99% of them would just give their books away at the end of the course. And perhaps not even 1% would then go on into the profession. Was simply a way of people getting permanent residency, and then they would go off and do something completely different. So I don't think that the skills points test is very effective at all. And I think that they're coming, sorry, very patronizing, but I think I was just about to say immigration's coming to their senses. But, in reality, with the economy as it is, with these pressures that there are from outside, this noise that's outside, the best way to justify skilled migration is to say, there's a vacancy. There's a skill shortage. This person is coming in to do that because other people don't want to do or cannot do those particular jobs. And then you can break through this. You can break through this noise. And if I was to write immigration, apart from family visas, which again are another really interesting area, certainly in terms of skilled migration, I would be saying to people, well, show us that you're skilled, but show us actually how you're practicing those skills when you're here in Australia.
So when, Lauraine, when is the right time, or when does it make sense to sponsor someone into their hire?
So I think Andy, just moving on what Andy's spoken about, where you sponsor an employee on a temporary visa, the minimum number of years they have to work for the company is usually two. Usually two, as usual average, obviously case by case basis, but usually it's two before then they may be eligible to be sponsored for the permanent residency transition. And therefore that creates a voidity of your employee. So I think retention is one great tool of keeping, especially in certain occupations where there are high turnovers of employees, and there are certain occupations out there. So retention is one. Second is just highly specialized skills. There are just several skills right now where just locals, it's just local, the current mobile market, there's no one really in that field or working in that field with those highly skilled. So if you do an advertisement and it comes up as, well, no one really fits the needs of the business, then the business may have to sponsor someone, and that might be more beneficial than leaving that position vacant. Same as if you already have an employee in that position, then, well, what's the advantage and disadvantage of then letting go of that employee to the business operation and the costs? Yeah.
And what would you do in a scenario where like the visa holder's role or circumstances changed?
Yeah, so that triggers the numbers. That triggers a lot of things. If it's roles, so as I mentioned before, there's compliance requirements. So if a visa holder jobs and duties has changed, seek advice immediately. I would say seek advice even before maybe promoting them to a different position, because it can trigger a number of things. One is reporting to the department that the person's role has changed. But before that, we usually then try to advise the company on what the actual consequences are, but what actually should be taken, because then the business might have to put in a brand new application again to then sponsor that person on the new occupation. Even though the business might think, well, there's not much difference. I said like a marketing assistants and sales, some occupations will overlap, but if the majority of the task has changed, that a new nomination that has to be put in. Then we have cases where someone's occupation was on the previous list, but then they now move on to a different position, and then that position is no longer on the current list. So then the new business can't sponsor them right now on that same occupation. So then we have to find a new occupation that fits with the new business operation to sponsor that employee. So yeah, quite complicated. I would say seek advice before doing anything.
So in this space, I guess luck plays a part in it as well. And I think good luck comes with great preparation. You can place a lot of your clients in really quick positions if you advise them early and formulate a strategic plan for them to move forward. But going back to you, what are some of the common mistakes that you have observed from employers when they are sponsoring?
Choosing the wrong occupation. That's absolutely that's fascinating. Again, the shoehorn analogy is quite prescient. Obviously, financial constraints and therefore paying people lower than the market salary rate. Immigration is very, very strong. That they want evidence to be shown that that someone is actually being paid what in Australia would be paid in a similar situation, similar conditions. And probably one of the biggest ones is this idea that, again, with labour market testing, if that's not done correctly, employers will often come along and say, well, we've advertised the position and we're fed up with advertising the position, so definitely don't ask to do it again. And then we'll check on their advertisement and find that it's waiting to be refused because it doesn't cover critical details.
With an element on their business website.
Absolutely, yeah. Well, we advertise, we put a sign up in the shop window. Why are we having it refused? And how far do we have to spread this advertisement to let people know that they can apply when we've already chosen the person we want to sponsor anyway? So that's probably the biggest one to overcome.
Yeah. Just mindful of time, I just want to turn to our audience online and in person. You got any questions for our panelists today?
What's one of the things that takes the longest in terms of preparing an application, both from sort of agents that you work with and also an individual? What's some of the things that the most likely thing to trip over that just really stretches out the completion time for a successful application?
Shop the labour market testing.
I think the labour market, if it's a labour market testing, is 28-day required. So many of these employer-sponsored visas are driven by a very strict timer. That's where it gets very stressful for everybody. Someone will inquire and say, we've got this person, their visa's running out in 6 weeks. And to them, my favourite expression, which I overuse, and I don't mind overusing, is that 6 weeks is tomorrow. In relation to protecting them, protecting both the employer and the applicant.
Any other questions? Yes.
Excuse me. So I've seen this in my business and also in clients' business around the 482 visa. And at the conclusion of that 4-year period, the sponsored individual, in our case, didn't want to move towards a permanent residency or a citizenship pathway, but still wanted to remain in Australia. And I've seen similar in our clients' circumstances as well. So what pathways exist? Has it changed? Because there seemed to be a hard stop at that 4-year period in relation to being able to remain as an employee of that original sponsoring company. Has that changed at all?
Well, the great thing about the 482 is that they've removed a requirement that you have to, and this was removed in December 2024, where you have to justify why you're only here temporarily and that you're going back. And that was a quite ridiculous requirement, because most people would be using it as a way to come and settle. If you're going to bring your partner and your children all the way over, but you're only going to be allowed to stay for 2 years and then another maximum of 2 years before you have to return, then obviously that was a huge barrier to bringing in serious people. But as an analogy, we've got a couple of individuals who can only apply to be sponsored for permanent residency before they are 45 years of age, but they don't meet the English language requirement. This is a fairly common problem. And so the conversations that I've had with those individuals and with their employers is that it is possible for them to stay on the 482 until the end of their lives. So they could be sponsored as long as the position stays the same, or until they retire, let's say, or before the end of it. But the fact is, they could get a 4-year employer-sponsored visa, and they could then apply for another 4-year employer-sponsored visa, as long as the genuine need is met, as long as immigration can see that the person is still fulfilling that goal, as long as the salary is there, and they don't need to advertise the position again and again and again. It's a very unusual scenario, but it is one where people realize that they can't permanentize. Is there such a word? They cannot make their residency permanent. However, they can be almost semi-permanent by being on a temporary visa for the rest of their lives, as long as the employer supports it.
I think answering that question, then obviously use that time to figure out another visa pathway, because I think most individuals know that once they're sponsored, their permanent residency status in Australia is linked to employer. And then obviously if they want to quit, they can't, right? Because then their visa gets cancelled. So yes, there are some individuals will then just use that 482 temporary, and then maybe they find a partner. Just look out there, find a Australian partner. There are other options out there they can find, and then go down that pathway, because then once you get DR through an Australian partner, you're no longer tied to that company. Yeah, and then you quit. Spread the same.
So we could book in another seminar like this, make it 3.5 hours, and we could just talk about partner visas.
Absolutely.
Just cover why partner visas are becoming. Go to the briefly. There are like 120,000 applications sitting in the system, where immigration has given 44,000 places. That's why there's a 3-year waiting for the visa.
One final question.
Yes.
Is there any unwritten preference as to certain countries? No.
What a great question.
Would it be too discriminatory?
Yeah. What a great question. Immigration follows a non-discriminatory policy in writing. Let's take the working holiday visa. This is fascinating. Every other country, from the richer Asian countries and European countries, young people under the age of 35 are allowed to come in for 1 year, and they're allowed to extend their working holiday visa for another year and possibly for a third year. The requirement is that they go and help agriculture, the agricultural economy, by going out to the regional areas and doing the fruit picking and so on. Oh, there's that expression, which the Australians don't want to do. There's the value of migrants, isn't it? Just in them working holiday visa. Through the recent trade agreement signed with the United Kingdom, here's discriminatory policy. British passport holders do not need to go and do the fruit picking. And they can just stay here for 1 year and another year to stay in the big cities. And no wonder, since G, there have been 40,000 young British passport holders who have entered the country. But then we could have another discussion about the collapse of the British economy, which I'm pretty averse with, in terms of my connections and so on and so forth.
Blue it even of 3 hours. I'm racing.
And you can see what's happening. There's Australia is the beacon. It doesn't appear to be a wealthy country from where we're sitting, but from outside, they call it a golden ticket permanent residency for a reason. And so people ask me regularly, how big is this market for migration? And I'd say about 8.5 billion population of the world. Minus the Australians, who are 27 million.
If you want, quickly, sorry. I always say, if anyone has time, go on the student visa checklist document online. Type in the RTO that someone's applying for a student visa, and then the country of passport, and then see what documents are required. Then put in the same RTO and then a different country of passport, and see what other additional documents are required. That's already telling you pretty much.
By immigration. And that changes. So people from a certain country wouldn't have needed to show that they've taken an English language exam to get into the country. Or that they need to show that they've got $50,000 to $60,000 in a bank account to support themselves. That wouldn't have been the case 1 year. And the following year, that requirement is then put there. So that's a lot of the tightening up. That's where it's moving away from volume driven. Post-COVID, it was, let's get everybody in because nothing was opening up quickly enough for the government. So things were really loosened. And really, I think what we're seeing in the since 2022 is really a kind of, trying to get back away from a net migration figure of 550,000 new migrants coming in every year. And they're bringing it down to about 310,000, but they want to get it down to about 225,000. I'm not sure those figures really mean to most people, but it's obviously in the battle of ideas that's taking place, the noise that's taking place around migration. These are kind of key areas, and that's why I think employer-sponsored visas pretty much cover all the bases.
Well, that will conclude our panel discussion this morning. I just want to take time to thank our panelists and the LLA, and to all of you who've attended very early on a Wednesday morning and those attending online. And please look out for our next morning breakfast session.